Right to ask, why am I being arrested?
Yeah. So this one is the defendant is charged with the crime of assaulting, battering, wounding, obstructing, endangering a state authorized person who is acting in the performance of his or her duties. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted, battered, wounded, obstructed, or endangered, officer, whatever, for who was performing his duties. Obstruct includes the use of Obstruct includes the use or threatened use of physical interference or force or knowing failure to comply with a lawful command. So a lot of times what they'll do is includes the use or threatened use, like, they'll say, well, she cocked her hand back. That's just an example. I'm not saying that in this one. Physical interference would be trying to push somebody away, or it could even be trying to block with your body, etc. Or force, which could be even just trying to pull away, or knowing failure to comply with a lawful command. So if they say...
What was the probable cause to this arrest? That's my main catch. What was the probable cause? So
here's where I think they're going to argue it, okay? I think they're going to argue it that they were performing their lawful duties because the judge told them to bring them to bring you back, okay? So they're going to bring you back. Now the thing is, and where your argument lies, is they come right up to you, and based on what I'm reading and based on what I've heard, Thomas say, and what, through him I've heard you say, is they immediately come up to you and put their hands on you. They don't say you're under arrest. They just immediately put their hands on you. Is that accurate? Okay. So they immediately perform an arrest rather than bringing you back into the courtroom, because they could have just asked you nicely to comply. Judge Kirkham has asked you to return to the courtroom. Did they give you that opportunity?
No.
Okay. Did you ask that question in your preliminary examination?
What did I ask in that preliminary examination? For one, the prelim, I was not able to cross-examine Christopher Owen, so that was...
They didn't call him as a witness?
Right, and they had me in the hole, and then they did not put it like this, the government interfered with everything that I was doing because I was representing myself, and I have proof that they interfered. So therefore, subpoenas could not go out to the people that I wanted at this preliminary exam, so no one was called at the preliminary exam but a sergeant basic, and that there was a violation of my rights, because I have every right to present witnesses at a preliminary exam. Probable cause was not established at the preliminary exam. That's why I feel as though a motion to quash this bind over should have been raised, but no one seems as though they want to raise that.
So, okay, I'm going to explain probable cause. Probable cause is an extremely low threshold, okay? Now, I agree with you that you had the right to present witnesses, and you probably didn't know your rights. You could have waived the 14 days, and that would have given you some more time. But they're not going to explain what your rights are, okay? So you could have waived the 14 days.
It was already adjourned.
It was already adjourned?
They had already adjourned the preliminary exam because they couldn't find an attorney to represent me. That was not my fault. Then they adjourned it, and then when it was time for me to present witnesses, I sent out everything in time enough, but the county jail, mind you, I'm charged with beating up their sheriff deputies. The county jail intercepted my mail, therefore no one got anything, so no one was there.
Because they were in jail? Or because you
I was
sent them out from the jail?
Yes, I sent it out from the jail. They placed me in the hole, which I only had an hour a day out to use a pen and piece of paper. Then the next day, the day before the preliminary exam, they give me subpoenas. You have to have 7 days in order to serve these subpoenas. Why would you give me these subpoenas one day prior to me going to my preliminary exam? And this was done by the Sergeant Callahan, the man who had tasered me. And so I have proof from my kites that I sent out that the judge was not getting my mail, that the people, that's why I was calling different people from the sheriff department, because I have grievances where I can introduce this as evidence that show that these people interfered with my mail going to the rightful place.
Okay, so let me explain probable cause. I think that we have something we can indicate, because you do have your right to have your witnesses there at the preliminary examination. You absolutely do have that right. Now, with regard to the probable cause, though, probable cause would have been found just based on the officer's testimony, okay? All the officer has to do is say, I gave her a lawful command, she didn't obey my command. She did X, Y, Z. She pulled away from me. She said, I'm not going to do it. I'm not, whatever.
Well,
okay?
this is the thing. You would have found probable cause on one case, but the other case you wouldn't have found no probable cause because this officer flat out lied and said the judge said to arrest me. By me not being able to call this witness at the preliminary exam, this case got binded over. This man wasn't even there to testify. His police report tells on himself. The videotape would tell. I could have played the videotape. I wasn't allowed to have any of this stuff at my preliminary exam, and I should have been able to. So therefore, I've been asking for this case to be remanded back to district court for a proper preliminary examination.
That is extremely difficult to do. Okay, I'm not going to sugarcoat it. It's extremely difficult to do. The first thing I need to do is take a look at the preliminary examination and go through that. Okay.
Mm-hmm.
I'm not going to get it from Mr. Marks until next week. Would you trust me to borrow your copy?
No.
Okay, all right. So I'm not going to get that till next week,
Mm-hmm.
okay? And so once I get that, I'm going to go through and I'll take a look at it and I'll see if I think that we have anything as far as teeth that can maybe at least. We can't file what's called frivolous motions either, okay? And it is difficult to get something remanded back.
Well, it's not that difficult because there's a thing called an interlocutory appeal. We'll have them look at everything. Yeah. You know what I'm saying?
So what I can do is when I get that information, or two, and I know it's a bit of a drive to come here to Marshall. If you want me to have that preliminary examination stuff sooner, if you would bring it here and then my staff can copy it, and or if you can scan it and email it to me, that would be another way. Okay. But I will get it from Mr. Mars, but not until next week. He's putting it in the mail. Okay.
I'll see if I can scan it and send it to your email.
Okay. All right, that'll work. And then that way I can look at it sooner, and hopefully maybe I can look at it this weekend. Okay. Mm-hmm. Now I'm going to give you a copy of what they basically have to prove. So going through this other one, it's second, the defendant knew the person assaulted, battered, wounded, or obstructed, endangered was then a officer performing his or her duties. And what they do is to establish that, they say, was the officer wearing a uniform? Was the officer identified as an officer? If this was like a public call, they would also say, did they arrive in a...
You can't say these officers was doing their duties because the judge didn't tell them to arrest me. So how are these officers doing their duties? Mm-hmm. If the judge said to bring me back into this courtroom...
And that's the argument.
He did not say arrest me.
And that's the argument, okay?
And he already lied on the judge in the police report.
Yeah.
That's big as day.
So that's the argument, okay? Right there is what the argument is. They're going to say they were performing their legal duties because the judge had ordered for you to be returned. They're going to argue that it was for the purpose of holding you in contempt of court, okay? And
there we go back on the contempt of court thing. Mm-hmm. The judge was off the bench. He had already dismissed me and dismissed himself. He was off the bench. So how can he charge me with a contempt of court? Is he off the bench when all this then went down? That's why you guys don't want him to testify. But I have every right to call that judge at the preliminary exam, just like I had it.
Me, guys, okay? Because I'm not them. I represent you, okay? So don't lump me in that, okay?
And basically, I already told you, based on your actions already, I don't trust you, and it's going to be hard for me to help assist in my defense in a rational manner based upon how you just got onto this case, and then you got the filing things and didn't even ask me.
Again, that was to protect your rights and to preserve your rights. But we can certainly file an amended everything, okay? Witness list and exhibit list. And we had that conversation to begin with, okay? But my purpose in doing that was to protect you. It wasn't to upset you or offend you, okay? It was to protect you and to make sure that we at least had a witness list in. And in it, and in the exhibit list, I preserved the right to amend it.
But he had already filed, this previous attorney already filed a witness list.
But his list may not be like mine. It may not have the same things that I want in mine, okay? So, that's the first thing that I do, right? Especially if it's an older case, because I want to make sure timelines are crunched, right?
Timelines, it's been over 180 days, and it wasn't on my fault, so my rights to a violation of a speedy trial, basically, it's been violated.
Yeah, except for you're free, so then that gives them a larger argument. Now, if you were incarcerated, that would be a huge argument in your favor. But one of the things that I also kind of bothers me about your case is the prosecutor's office is clearly not willing to give you an offer, okay? I want to talk to you about, do you want an offer? Because if you do, I can go to the judge to see if the judge will provide what's called a Cobb's agreement. And that's an agreement between you and the judge.
I was supposed to been basically they sent me for a mental health court. Okay, now they're saying that they can't take this case, but other counties could take this case in mental health court. Why didn't I qualify for mental health court? It's just shut. The door just was shut on me. Currently, I am a mental health patient. I receive SSI. I go to counseling. I have a therapist. Everything is through mental health. How come basically I'm not qualifying for mental health court?
Well, and I'll tell you, essentially what it is the mental health team sits down and they talk about a particular individual and whether or not they feel that that person qualifies for the court. It's based on some kind of criteria. I don't have that information, so I can follow up on it to see why you were denied. Okay?
Yes.
Sometimes they'll say it's because of assault of crimes within the history.
And that's where I seen where another county take those assault of crimes, and I would have to go through there. But
So,
I was not even given that option.
And each county gets to decide what their parameters are. But you are correct. This is a situation where it's a group of people that sit down and determine the fate. Okay? There is an aspect to this where if they don't like you, they can say, we're not taking Vicki Hamer.
And that's exactly what happened to me, because who started this case was Brandon Hall Tink. He was a prosecutor at the time. Now he's an attorney. His wife oversees it.
Okay.
It's just not. I've been dealing with mental health issues since 2017 years.
What are your diagnoses?
Mood disorder, depression, and it's manic depression.
Okay.
And mood disorders.
Anything else?
I can't, right off the bat, I don't have it, because it was another disorder as well.
Okay.
So it's just not like overnight, I didn't have mental health issues. I've been dealing with mental health issues for 17 years.
Okay.
And another argument. If I would have heard that judge, I would have had no problem coming back into that courtroom. I show up for every court appearance, anything I show up for. So why wouldn't I have came back into this courtroom? If I've heard what this judge said. If he's yelling and I'm yelling, of course I'm not going to hear what he says, because both of our voices are elevated. So I didn't get to hear what this man had said.
Okay, so that's one of the questions. If this does go to trial, I am going to ask you that, okay? And that's a perfect answer. Saying, look, if I had heard him, I would have come back. If the officer had come up to me and said, Ms. Hamer, Judge Kirkham is asking you to return to the courtroom, I would have turned around voluntarily and come back to the courtroom.
But these are the same officers who had been, how can I say this? They had been harassing me. When I come through the courtroom, they sit there, they let my son had this case. And so the people's family with they're yelling obscenities at me, but then if I say something, these the same officers who jack me up in a corner and threaten to arrest me because they're threatened to do great bodily harm to my son, and I'm just was supposed to just sit there and don't take it. They act like they don't hear what these people threatening us, but I have to sit here and take it, but they want to arrest me but not say nothing to them. Sergeant Basic and Deputy Owens, these were the same too. There was a history there.
Okay, so what kind of threatening comments were being made?
They said when we stepped off the coming through the thing, they was like, yeah, that's that nigga right there. Yeah, we gonna kill you. They threatened to kill my son. His name was El Marco Williams, and other one name was Malik Williams. When the situation happened with my son, they all were right there. And then I ended up in an argument with the boy's grandmother, because she was, talking about what she's going to do. And I told them they're not going to do nothing to my son. And they jacked me up. Officer Owens jacked me up, threatened to arrest me. And then after the hearing, Sergeant Basic said that we couldn't go out the front door. We have to go out, the side, the back door, because you heard the threats that they gave you. And so we had to, go out this back. But nothing was done to the crowd of people where these officers heard what these people said to us. Absolutely nothing was done.
And Thomas, you were also told that you couldn't go out the front door?
Yeah.
Okay. Okay. Alright, so I'm going to give you these because this is how they're going to use to try to establish, okay? So that you have an understanding of what they're doing.
And also, I have how my mental competency exam, because they were not supposed to do a mental competency exam and a criminal responsibility all in that same time. That's not how that works.
Oh, guess what? Prosecutor's office just sent me a transcript.
Okay.
Okay? So I've got that.
Okay.
So don't worry about that. July 9th of 2015?
Yes. It was Daniel Busher.
Busher, yep. Okay. Okay, yep, so I just received that, okay? And then I'm sure they'll get that disc to me. I'll probably pick it up tomorrow if they can get it burned today.
Okay.
Let's see here.
So basically, what I'm saying is this: I still have not had my correct right to my mental competency exam, because I had the right to go to the forensic center and get an examination by a licensed psychologist, not a limited licensed psychologist. This lady was a limited licensed psychologist, so another psychologist had to sign for her report.
Mm-hmm.
That's not what I get a right to a full psychologist who can sign for their own report. I had to get this limited license. Not only did she do a mental competency exam, she did criminal responsibility as well, all at the same time. But yet, they only heard the mental competency exam. They never, heard criminal responsibility. It was just like forgetting. And that's a violation all in itself on how all that went. And so then the psychiatrist, center psychiatrist said if I already had an evaluation, I couldn't come back and get another one. So that's why I'm end up with this independent evaluation. But they did not follow their own laws dealing with that situation.
Okay, so you're saying that you never had a criminal responsibility hearing?
No, I never had a criminal responsibility hearing at all.
Okay, so I'm going to follow up on that.
And I got the criminal responsibility thing done right when they were doing the competency exam at the same time.
Yeah, they do that. You're not the only one that's happened to. Okay, let me print off your police reports so I don't forget, okay?
Mm-hmm. In the police report, the main argument, Officer Owens lied on Judge Brian Kirkham. That's why I asked for Kirkham to be there, because Kirkham never told them to arrest me. In Christopher Owens' police report, he said he was doing what the judge told him to do to arrest me.
Yeah. Yeah, so that is also going to come in through the video. Now, in speaking with Mr. Marks did have Judge Kirkham listed on the witness list for you. Did he let you know that he had received contact from the court with regard to that?
It was something that they didn't want him to testify.
Right, that they were going to file a motion to suppress, etc., etc.
Mm-hmm.
So, let me see, 1, 2, 3, 4, and 5.
And explain to me this too. How was Karen Kelly prosecuting this case when Karen Kelly was the alleged witness? She was right there on video, looking, laughing, relating things to the judge, but yet she's been prosecuting me all this time. That's a malicious prosecution.
Well, yeah, that one is going to be a little bit more difficult to prove because she's not necessarily the one that authorized it. So I'll have to check to see who authorized it, okay?
Rachel Dermott authorized it, but each court appearance, Karen Kelly is there.
Mm-hmm. Because it has been assigned to Judge Lincoln. And she's assigned to Judge Lincoln's courtroom. Mm-hmm.
So if she's a witness to a crime, she knows she's not supposed to be prosecuting the defendant, especially when the defendant.
She can prosecute as long as she doesn't personally testify. Okay. So if she were to get up there and she were to give some personal testimony with regard to something that she observed, that would be inappropriate. That would be a mistrial. Okay.
I got her called as a witness, and she knows she's being called as a witness, and she keep showing up, basically bringing on this prosecution.
Yeah, so then if she's called as a witness, she can't be the prosecutor. It would be her partner, Karen, the other Karen.
But yet, even at the criminal status conference, she's there. Everything she's there. I have witness and proof she's there. And she's on that tape laughing to the judge. And she's on tape telling the judge about, she went to prison last time.
Yeah. So if we use that tape, we have to talk about if we want that part to be left out, where she makes the comment about you went to prison last time. Because if we show that in front of the jury, then that tells the jury you have a prior criminal record. Okay.
Well,
so
it's going to be used.
Whether or not.
It's going to be used.
Okay. All right. So I can try. Do you want me to file a motion to keep that portion out, where she makes that reference?
No, because I want the jury to see her laughing and everything, and what she was telling the judge.
Okay. Keep in mind that could backfire because
it's okay.
The jury could look at that and say, you've already been in trouble before.
Mm-hmm.
And it kind of opens the door for them to bring in your prior criminal record.
Mm-hmm.
Okay? So that could be a mistake.
I'm not worried about the prior criminal record, because if they want to bring in the prior criminal record, then that's when we'll use Judge Sent motion, where Judge Sent said that my arrest was illegal and I shouldn't have never been arrested for anything. And based because I had ineffective assistance of counsel is the reason why I was convicted.
Okay. Yeah, so maybe get that information to me and scan that to me and send it to me. I think that is something that you're going to use because I'm having to use it as an exhibit. All right, there's one photograph, and this photograph is not going to show up if I print it. So I'm going to show you the photograph, okay? So this is the officer's arm, and it shows a bunch of scratches and blood.
And this officer testified that pictures were taken. It was of his glasses, and it was. They took the pictures of the glasses and put the pieces like that, and everything matched up, and pictures were placed into evidence. You're going to see that in the
You have your results from the exam, correct?
What do you mean results?
You have the reports
From what?
from the examination.
No, I'm going to need another copy. And this was the transcript from my previous arrest of the what you call them, the resistance arrest.
Okay. Is this for me to keep, or do I need to
If
make
you
a
can
copy?
keep that.
Okay.
But the original case, we had to get it from the original case. I think that was 2004. Is either 1981 or 1982 when Thomas, he went first, and Judge Sent ruled that my arrest was illegal. The police had no business breaking into our home, arresting anyone. And I had ineffective assistive counsel. I was taking a trial. I wasn't even able to be present at my trial because I said I did not want this attorney representing me. I was kicked out of my trial. The next thing I know, I was convicted and sent to prison on this. Even with this, the judge would not let them see this.
So this was initially brought against you, and then it was kicked out, and then they brought it back again.
No, this was me and Thomas was co-defendants.
Mm-hmm.
They arrested both of us out of our home.
Okay.
So Thomas went to court first. He had a different attorney.
Mm-hmm.
And in his motion to dismiss, the case was dismissed with prejudice.
I see you, because this has got Thomas. This is Thomas's
Right.
exam.
They brung up, that my arrest was illegal. There was nothing I could have been arrested for. But yet my attorney, who was Thomas' attorney to sue, he was supposed to sue the Battle Creek police for what they did to him.
Mm-hmm.
He never filed Thomas's lawsuit. And he jacked my case up and got me convicted and sent to prison. With this, because he got this throughout where the jury could not see what the judge had already ruled in my case.
Okay. All right.
And the main thing, I had every right to question Christopher Owens at that preliminary exam. I did not get a chance to question Christopher Owens at that preliminary exam. And so there's going to be no testimony from Christopher Owens in that preliminary exam. And at that time, I did put my objection on the record at that prelim that I had every right to call Christopher Owens. And wasn't no one there. Only one showed up was Karen Kelly. And I wanted to call her, but the judge would not let me. So,
Okay, here's the competency to stand trial. And the criminal responsibility criminal.
So my question is to you. What standing does the judge have if he's off the bench?
I'm going to have to look at some legal law for that one. Okay?
Because he was off the bench and the tape will show he was already off the bench.
He had closed the record, but he was still in his gown. He was still in the gown, and he was still seated at the bench.
He wasn't seated at the bench. He was standing. He was up. The judge was up. The videotape will show the judge about to go that way. Then he said, bring her back in here.
Okay, so I'll take a look. It's been a while since I've looked at it, so I'll get it and I'll look at it again. And then I'm going to have to do some research. Okay.
Because I have a right to call that judge. Because this police report, this officer flat out lied on this judge. And this police report is still standing.
Now, really quick, okay, I want to go